Could publish that, please.
Roll him on the side.
No, stand put where you got him.
Stop. All right. Now, at that point, you could hear somebody in the background, correct?
Yes.
You heard Mr. Floyd, true?
Yes.
His voice appeared slower than before?
Possibly.
Thicker than before?
And what?
Thicker?
Yes.
Right. You also heard conversation, normal tone conversation between Officer Lane and the defendant, correct?
Yes.
Officer Lane said, roll him on his side, right?
Yes.
And what was the defendant's response?
Something not yet.
No, keep him here,
Okay.
right? And so, at this point, Officer Lane is suggesting that they roll him on his side. Would that be consistent with the side recovery position?
Yes.
Okay. And the defendant is rejecting the side recovery position at this point. True?
Yes.
He's hearing his information from his fellow officer, deciding a different course of action. Nothing the crowd's doing is preventing them from having that conversation. Is that right?
Not that I'm aware of, no.
And in your view of the clip that we just looked at, just focusing on the subject behavior, what is Mr. Floyd doing? What was he doing in that clip?
He's becoming more compliant.
Well, is there any non-compliance you were able to see in that clip?
In this clip, no.
And so he's not exhibiting non-compliance, and based on your testimony and your review and the plain video record in front of you, you see that the defendant has not changed his position, correct?
Correct.
He's still applying the same level of force that he did at the beginning of the restraint period, true?
That I can't say.
He's still kneeling on Mr. Floyd, correct?
Yes.
And you're not contending this was some sort of an accidental position, right? He didn't fall down onto Mr. Floyd, and he was purposefully kneeling on him.
Yes.
True? Okay. All right. And so, based on your view, right, of the defendant being on top of Mr. Floyd, up to this point and beyond this point, the defendant did not alter the level of force that he was using on Mr. Floyd, did he?
No.
Even though Mr. Floyd, by this point, had become, as you put, compliant. Fair?
More compliant, yes.
Well, what part of this is not compliant?
So I see his arm position in the picture that's posted.
Right.
That, you know, a compliant person would have both their hands in the small of their back and just be resting comfortably, versus like he's still moving around.
Did you say resting comfortably?
Or laying comfortably.
Resting comfortably on the pavement.
Yes.
At this point in time, when he's attempting to breathe by shoving his shoulder into the pavement.
I was describing what the signs of a perfectly compliant person would be.
So attempting to breathe while restrained is being slightly non-compliant?
No.
No. You're aware, if we could take a look at Tao's body-worn camera starting Exhibit 49 at 20:23:38. And at this point, you see this Tao's body-worn camera, we see more people here, correct?
Yes.
Right. You still see the teenage girl with the cell phone?
Yes.
She's joined by what appears to be a juvenile female, correct?
Yes.
Wearing a love shirt,
Yes.
right? Another teenager filming, is that right? And you see that?
Yes.
And then there's an individual in a hooded sweatshirt standing on the sidewalk, correct?
Yes.
All right, if you could play that.
We're done.
You circle
Okay, we're
like
done.
in a jiu-jitsu move,
We're done.
bro. You try
We're done.
this breathing right there, bro.
Okay.
Like, you don't think that what it is, bro? You don't think nobody understands that shit right there, bro? I trained at the academy, bro. That's some bullshit, bro.
You did. Okay.
Right,
Then you
that's
understand.
bullshit, bro.
All right.
That's bullshit, bro. You fucking stopping his breathing right there, bro.
Okay, he's talking.
Okay, well, you heard Mr. Tao say he's talking, correct?
Yes.
Referring to Mr. Floyd, right?
Yes.
I guess he was talking, wasn't he?
Yes.
And he said, I can't breathe, right?
Yes.
And it was even more slow at this point, correct?
Could have been.
And this is well within the restraint period, true?
Yes.
And the individuals here, in terms of the volume you're hearing, you don't hear this person saying anything, do you?
No.
Or her?
No.
Or her?
No.
Or him?
No.
Or him?
I'm not sure of that.
The
No.
gentleman in the blue shirt with the baseball cap.
No. Didn't hear him say anything.
Didn't hear the guy behind the person in the hooded sweatshirt say anything, in the plaid shirt there?
I didn't hear him. No.
Okay. And so the only person that you would have heard say anything is the person in the hooded sweatshirt, correct?
Yes.
And what was he saying?
Something about get off him, bro. You don't learn. You don't teach that in the academy. You don't learn in the academy.
He said you're cutting off his breathing, right?
Okay.
Fair to say he was expressing concern.
Yes.
And in this moment, was this crowd a threatening crowd?
No.
All right, I'm going to take you to Exhibit 127 at 2024-18. Please publish that.
In the car by now, bro. He's not resisting arrest or nothing. You enjoying it. Look at you. Your body language explains it. You fucking bum.
It's the whites. They love
But,
to mess with
yeah, I already know that, bro. I trained with half of these bum ass dudes at the academy, bro. You know that's bogus right now, bro. You know it's bogus. You can't even look at me like a man because you a bum, bro. He's not even resisting arrest right now,
His
bro.
nose is bleeding.
He's fucking stopping his breathing right now, bro. You think that's cool? You think that?
Okay. During that time period, and I don't know if you heard, did you hear another officer, did you hear the voice of Officer Lane say he's passing out?
I didn't hear that. No.
Did you hear Mr. Lane say that at any point in your analysis of these videos before you came to court today?
About what Mr. Lane or Officer Lane said?
That's correct.
Yes.
Yeah. And so you heard him say at least one occasion he's passing out, correct?
Yes.
And would you accept my representation that that would have occurred around this time during this clip?
Yes.
All right. And other people, bystanders, are saying the same thing, correct?
I heard mostly just what the one gentleman was saying about being a bum and not resisting arrest and things like that.
Right. That the defendant was being a bum and that Mr. Floyd was not resisting arrest, correct?
Yes.
And you just saw the video. You saw Mr. Floyd, what he was doing at that time. At that time, would you agree, and I'll tell you the name of the person, it's Donald Williams. Would you agree with Donald Williams that Mr. Floyd was not resisting arrest at that moment?
Yes.
Mr. Floyd doesn't appear to be conscious at the end of this clip, does he?
I can't tell.
And you're certainly not as close to him as the defendant was in that moment, correct?
Correct.
He's not talking, correct?
Yes.
He's not resisting.
Doesn't appear to be, no.
And from this point forward, the defendant remains on top of him in the same position as when he started the restraint period. Isn't that true?
I would say the same general position. I wouldn't say the same exact position.
Yeah, same exact position, same general position. The position is such that he's on top of him, compressing his lungs, compressing his chest against the pavement, right? With his body weight.
It's in a prone control position.
In a restraint. He's restraining, correct?
Yes.
Can't move, right?
Floyd can't move?
Floyd can't move.
No.
He's not moving. He's not resisting. He's not talking. It's not possible, is it?
To do what?
Resist
I think it's definitely possible to resist.
when
It
you
just-
passed out. He's not doing it here, is he?
Not when he's passed out, no.
When we talk about what's possible, let's talk about what's happening in this case. He's not resisting, is he?
And this snippet, no.
Right. And from this point forward, right? From this point until the point at which the EMTs arrive and tap on the defendant's shoulder and take Mr. Floyd and place him onto the gurney. From this point to that point, Mr. Floyd wasn't resisting, was he?
No.
The defendant maintained the same general position.
Yes.
Force must be reasonable at the start of the force, correct?
Yes.
Throughout the continuation of the force and at the end of the force, correct?
Yes.
And you reviewed these videos and you understand that by the time the defendant got off of Mr. Floyd literally could not support his own head. Did you see that?
Yes.
You see the way he moved, the way his head moved when they moved him onto the gurney?
I did.
And a reasonable police officer in the position of the defendant, and that position is the position we see here, on top of him, would know that, right?
Would know.
That he's not responsive, that he's not resisting.
I think he would know he's not resisting.
Because the officer said that he wasn't breathing. Said that to the defendant, right?
The officer did, or what the bystander?
Mr. Lane. Mr. Lane said that.
Can you rephrase because I got lost in.
I'm sorry. Mr. Lane said that. Mr. Lane said that to the defendant in the prior clip we watched, that he's not breathing, right?
Well, I heard that he's passed out. I didn't hear the not breathing part.
Well, the passed out came from the bystander, right?
I'm not sure.
Did you hear at some point in your review Officer King say that he couldn't find a pulse?
Yes.
All of this would have been known to a reasonable officer in the defendant's position, correct?
Yes.
And the defendant's position is and was and remains, as we see here at this moment, in this time, in this clip, on top of Mr. Floyd, on the street. Isn't that right?
Yes.
I have nothing further.
Mr. Broad, you were asked a lot of questions on, oops, if we could take this down here. You were asked a lot of questions on cross-examination about the prone control position. Do you recall that?
Yes.
Can you describe what specifically you mean by the prone control position? What is the placement of the knee relative to the back, neck, shoulders, etc.?
Ideally 45 degrees in between the neck and shoulder blade.
So 45 degrees coming in from the side.
Yes. Angling down towards the lower body.
And where would the shin be placed?
Just below the knee, same thing around the trapezoid area.
So there's a kind of a hard spot in between the base of the neck and the shoulder blades. Is that the area you're talking?
Sustain.
Can you describe by touching your back the area that you're describing?
So the knee would probably end up pretty much on the spine, and the shin would be along the trapezoid.
Okay. And during the course of this, your testimony, you were shown several, short clips of things happening from time to time. Agreed?
Yes.
What's the problem in terms of the analysis by looking at just specific short clips?
Doesn't really show the sequence of events, just shows little highlights of it.
In terms of the analysis, the standard being the totality of the circumstances. Agreed?
Yes.
And so when we kind of pick and choose, does it take into consideration everything that happens or that a reasonable officer would be doing at any particular time?
No.
And what would be another phrase for that?
kind of picking and choosing.
Like 20/20 hindsight?
Objection, leading, and argumentative.
Sustaining on both.
I'll withdraw. Now, in terms of the, when someone is in the prone control position, you testified that you don't consider that to be a use of force, correct?
Correct.
And that's why again?
It's a control hold. So the suspect is controlled, hopefully searched, and all you're doing is putting some minimal body weight to keep their body immobilized.
Does it impact the structures of the neck?
No.
Can a suspect continue to lift up his head, move his head around?
Yes.
Do you observe Mr. Floyd doing that while he's in this position?
Yes.
Did you observe him use his face to try to lift up his body?
Yes.
Did you observe throughout the course of this event, did you observe Mr. Floyd's right arm in various body-worn cameras?
Yes.
Did you observe his veins during that?
Yes.
What did the veins signify to you?
Had strong pulse. He looks very muscular.
Objection, foundation, Your Honor.
Overruled.
In terms of when Mr. Chauvin first arrived on scene, what would have been the first thing Mr. Chauvin would have seen?
The struggle that Mr. Floyd was giving to Officers Lane and King.
And does that come into consideration of the analysis of the continued use of either force or a prone control?
Yes.
How about 1 versus 3? How does that factor into the analysis?
I'm not sure if I understand the question.
Certainly. You've observed the struggle between officers and Mr. Floyd. How many officers were there?
2, and then Officer Chauvin was the 3rd.
Okay. And how many suspects were they attempting to apprehend at that time?
Just Mr. Floyd.
Did Mr. Floyd, did all 3 officers at any point attempt to get Mr. Floyd into the back of their car?
All 3 did.
Were they successful in your analysis?
No.
So does the analysis in terms of, again, the continued use of force or putting someone in a prone restraint include what happened moments before?
Yes.
And so if one person can overpower 3, is that a factor to consider in whether to use a prone restraint or control technique?
Yes, because it takes some of the strength that the suspect may have away from them.
Are you familiar with what we would call the swarm technique?
Yes.
Can you describe for the jury what the swarm technique is?
It's where multiple officers will use their body weight to pin a suspect down to the ground.
And the purpose is?
Control.
And at the beginning of the prone position of Mr. Floyd, did you observe Mr. Floyd continue, at least initially, to actively resist?
Actively, and with the kicking motion, active aggression.
So let me ask you, in terms of the concept of active aggression, that's taking a swing or using some force against an officer, is that correct?
Yes.
Does active resistance have to be violent in order for it to be active resistance?
No.
Are there levels of active resistance?
Sure.
So can you explain how the level of active resistance may change?
So pulling away from an officer would be one example of active resistance. Just muscle rigidity, refusing to let an officer pull your hands away from your body would be another example.
Okay. So there are, like all things, sort of a spectrum of active resistance, active aggression, or passive resistance, right? There's a spectrum of it, right?
Yes.
And during the course of the restraint of Mr. Floyd, do you continue to see Mr. Floyd actively resist to some degree?
Yes, he was struggling.
And how would you describe that within the spectrum of active resistance?
He's a very strong individual, so a lot of that has to do with individual capability. So He was still struggling the efforts of the 3 officers to control him.
A reasonable officer, in terms of making a decision to keep someone in a prone restraint, can take into consideration the actions that occurred immediately before.
Rephrase. Sustain.
Is it possible for a reasonable police officer to, I'll rephrase, I'm sorry. Is the decision to use force or a restraint technique a spectrum similarly?
Yes.
And officers are trained to assess the risk.
Yes.
It's preliminary. Overruled.
And the threat.
Yes,
Those were some questions you were asked about.
they were.
Why is it important to have a suspect in custody under control?
For the safety of the officers and safety of the suspect.
And if a suspect becomes more compliant and less actively resistant, does that eliminate the officer's ability to maintain a restraint?
No.
You were asked several questions about Mr. Floyd stating that he couldn't breathe while he was being restrained. Did you hear those same statements during the struggle inside of the squad car?
Yes.
Did you hear them more than once at that time?
Yes.
Did you hear him state that he was claustrophobic?
Yes.
Would a reasonable officer consider the actions of that person in relation to the words?
Yes.
If a person is saying he can't breathe and continues to actively resist, albeit at a lower level, would an reasonable officer take that into consideration?
Yes.
You were asked a series of questions about a singular point in time when Mr. Chauvin's his toe came off the ground. Did you interpret that to be an increase in the amount of force applied to Mr. Floyd?
I couldn't tell.
You described in your cross-examination that he had to sort of catch himself on the squad car.
Yes.
Would you interpret that as a lack of balance or an effort to apply a greater amount of force?
I think reaction to Mr. Floyd's body movement made the officer lose his balance momentarily.
Do you think that if you're on 2 knees, there's nothing underneath you, 2 knees on the ground, right? Is weight permanently equally distributed between those 2 knees?
Objection leading and beyond the slope.
Overruled on both grounds.
No.
Do people sort of move around?
Yes.
Do their weights shift?
Yes.
Do you observe that happening in this case?
Repeatedly.
Do you observe Mr. Chauvin or Officer Chauvin relieving some pressure at times when Mr. Floyd moves?
Yes.
Is that consistent with a prone control restraint?
Yes.
You were shown some videos when the first young woman first came and started filming at approximately 20, 21, and 29 seconds. Do you
Yes.
recall that? Did you factor into your analysis the timing of when EMS was called and then subsequently increased to their response rate?
I'm not sure if I understand the question. Sure.
The videos that you watched, some of the videos you watched when Ms. Frazier began filming at 20:21:29, if EMS were called at 20:21:35, code 3, does that factor into the analysis?
Yes.
Why?
Knowledge of the area and the fact that they anticipate the response time is going to be very rapid.
Can you underestimate a member of a crowd or a group of people simply by virtue of their age?
Certainly.
Is it possible that a 17-year-old person can place as an officer in an equal amount of danger?
Absolutely.
You've seen other videos from other officers and you became aware, or did you become aware of the traffic patterns and the number of people driving by?
Yes.
In terms of the position of the officers relative to traffic,
Objection beyond the scope, Your Honor.
Overruled.
how does that again factor into the analysis during this time frame?
That would be an environmental hazard since they were almost in the traffic lane and there really wasn't any protective barriers around them.
I'll show you. One second. I'm going to just show you one snippet at 20:24:01 from Officer Lane's body camera. Is already in evidence, I believe, as Exhibit 49.
No, it's just hard to get him off the ground. You're being a bum right now. You can get him off the ground, bro. You can get him off the ground. You're being a bum right now. He enjoying that. He enjoying that shit. He enjoying that shit. He a fucking bum, bro. He enjoying that shit right now, bro. You could have fucking put him in the car right now, bro. He's not addicted to the rest of the stuff. You enjoying it. Look at you. Your body language is crazy.
Ending at 20:24:26, did you observe Mr. Floyd's leg in that moment?
Yes.
Would a reasonable officer interpret that to be a form of active resistance?
Possibly.
Did you observe, how did you observe Officer Lane push that leg down? Was it gently or forcefully?
Forcefully, he took both his hands.
If we could take this down, Your Honor, for a moment. I'm going to show you what's been introduced as Exhibit 1020, which is the point at which the ambulance and Mr. Chauvin stands up towards the end of this restraint. And I'm going to ask that, this is already in evidence, I'm going to ask for you to make a determination as to where you think Officer Chauvin's knee is.
Looks to be on the left shoulder blade of Mr. Floyd.
So it's fair to say that throughout, we'll just finish with this finish. Did that appear to be consistent with the prone restraint hold that you described?
Yes.
So if we can publish that to the jury then, just. Would you agree that on the left-hand side it appears that Mr. Chauvin's knee is on the neck of Mr. Floyd?
No.
How about on the right?
No.
So from that perspective, Mr. Broad, does it appear to be consistent with a reasonable officer's use of the prone restraint technique?
Yes.
Is that sort of the problem with snippets?
They don't show the full picture.
Would you agree that well, you tell me, if a group of people is compliant and passive at one moment, does that mean they're going to be at the next?
No.
Is a reasonable officer prepared, should a reasonable officer be prepared to expect a change in a crowd?
That'd be part of the situational awareness and planning process.
If one perceived threat or risk emerges while you're dealing with another, how is a reasonable officer trained to determine which risk or threat he should be dealing with?
The officer's trained to address what they perceive to be the highest risk.
If a reasonable officer has reason to believe that a person is passed out, can a reasonable officer be trained that if that person comes to, they may be more violent?
They could.
Has that happened to you in your law enforcement career?
It has.
And is that something a reasonable officer would take into consideration in assessing whether it be a use of force or a use of prone restraint?
They should take it into account.
Would that cause a reasonable officer to be more or less concerned?
Aware and more concerned.
I have no further questions.
Any recross?
I do. So you're not still contending that the prone restraint here was one that would not be likely to cause pain, are you?
It could cause pain.
Could cause pain, did cause pain, correct?
I don't know if it caused pain. I'm saying it could cause pain.
Did you look at the autopsy photos? Were those submitted to you?
No.
Right, so you didn't see the bruises on this man's shoulders? You didn't see that?
No.
You didn't see the bruises on his face?
No.
You couldn't use your context clues to determine that somebody trying to lift their body up with their face against the pavement, that would cause pain? It would cause pain, wouldn't it?
Lifting the face up off the pavement?
That's right.
Not
No,
necessarily.
using your face to lift your body up off the pavement. That would cause pain.
Objection? Overruled on that ground.
That could cause pain.
The only struggling that you saw Mr. Floyd doing after he was restrained was struggling to breathe. Isn't that right? Well, that
Overruled on that ground.
I don't know. If he was struggling or was he struggling to catch a breath, I can't tell.
In any event, struggling to breathe is not active resistance, is it?
To me, no. To the officer, maybe.
But officers are trained in terms of the dangers of positional asphyxia. Officers are trained that there can be a physical response to having oxygen deprived of you as a result of the pressure. Isn't that right?
There can be.
Overruled. You can answer.
They're trained about that,
Yes.
correct? And it's much like the analogy that's used if somebody's holding your head underwater, there's a natural reaction to struggle, correct?
Yes.
And that's the danger, right, of the cycle of positional asphyxia, is that the officer might not recognize that what they're doing is causing the person to react. True?
It's quite possible.
And you don't contend that it was reasonable for the defendant to hold Mr. Floyd down on the pavement in this position to avoid him getting hit by a car, are you?
No.
No.
I said no.
All right. All right. Thank you, Your Honor. Nothing further.
Anything further? Thank you, sir. You may step down.
Thank you.
Members of the jury, our next witnesses are not available till tomorrow, and so we're going to recess for the day. The lawyers and I have some issues to deal with right now, and also at 8:45 tomorrow. But we still hope to start about 9:15 or 9:30 tomorrow. Hopefully, we'll be done with our issues by then. So, have a good night. Don't talk to anyone. Don't watch the news. Thank you. Counsel, we have some time here at the end of the day. We had some cleanup matters as far as exhibits, and some that were provisionally offered and some that were, I think everybody assumed were offered. Mr. Frank, anything you'd like to do to clean that up, or?
Sure, Your Honor. You gonna stay here? Am I back close enough to the microphone?
You're close enough to that microphone and it is on, so.
Your Honor, we have a number of questions regarding exhibits, and I think we can deal with them on the record at this time. Your Honor, we understand that Exhibit 15, the record may reflect it had been conditionally offered through Donald Williams because Ms. Frazier was going to testify later. If it was not made clear that that was then being formally offered, sufficient foundation was certainly laid for that during Ms. Frazier's testimony, so we would ask that Exhibit 15 be formally offered at this time and received.
Any objection to that, Mr. Nelson? Is formally received.
And Your Honor, we had Exhibits 922 through 951, slides that were used during Dr. Tobin's testimony, and we just want to be clear that the record reflects we are agreeing that those should be considered only as demonstrative exhibits and should not then go back to the jury as substantive exhibits.
Agreed, Mr. Nelson?
Agreed.
It did appear that they were demonstrative at the time, even though it was not specifically stated, so we'll change the status of those to demonstrative only. It will not go back to the jury.
And Your Honor, during Dr. Smock's testimony, there was reference to a demonstrative about the signs of excited delirium. That may have been referenced as 921, or I'm sorry, may have been referenced as 941 when it was actually 921. 941 obviously falls within the exhibits we just talked about as demonstrative. So that we believe should be marked as 921. We understand that that's a demonstrative anyway and would not go back to the jury.
Is that correct?
Just have it 1 second. I'm not doubting Mr. Frank. But
So one more time, Mr. Frank, 941 should actually be 921?
I think it may have just been referenced during court as 941. We have it marked as 921, and it's a demonstrative anyway.
All right. So, Mr. Schaefer, how do you have it?
That's the 10 signs of excited delirium.
Correct.
Yeah, I had it in the record as 941.
All right, leave it as 941? Demonstrative only, or did you want?
So then there would be two 941s. So when
Correct.
it should be 921.
So the slide deck on excited delirium, which was marked and received as 941 for demonstrative purposes only, should be remarked as 921 for demonstrative purposes only.
Correct.
I believe that's correct, Your Honor.
All right, so ordered.
And Your Honor, during the testimony of Chief Arredondo, there was reference made to Exhibit 269, which was the map of the Minneapolis precincts. Our records show that that was offered and received, but maybe some question about that. So at this time, we are formally offering 269.
Any objection to that? That's the colored precinct map, is that correct?
Correct.
No objection.
269 is formally received. Can we return back to 9? I forgot what we finally marked it as. The excited delirium slide deck. 921. I think the record should reflect we had a chambers conference about redaction of that before it was given to the jury.
No, that's a different one, Your Honor.
Right.
Okay. I'll wait for you guys, and I'll speak when you speak to it. Because we did have a chambers discussion on a redaction.
That will be 1,053-ish, but we'll come back to that, if we can.
Sure.
Okay. Your Honor, Exhibit 110, which is one of the Minneapolis Police Department Defense Policies Training Guide. We indicate it was offered and received during Lieutenant Mersel's testimony, but there may be some question about that. So just to clarify for the record, we are formally offering 110.
One moment, Your Honor.
And that was, again, your description?
It's the Defense and Control Response Training Guide.
No objection.
All right, 110 is formally received.
Your Honor, Exhibit 255, we indicate that it was offered and received during Sergeant Steiger's testimony, but again, there may be a question about whether that was actually done, and so we would just formally offer 255 at this time.
Mr. Nelson?
155.
255? And what's the description of that again, Mr. Frank?
It is a screenshot from King's body-worn camera at 8/19/35.
That's one I don't have a copy of. 255, I don't have a copy of that one, counsel.
255?
And it was at what time?
8/19/35.
So 2019, 35.
Correct.
You have that it was offered and received, but the court doesn't, right?
Correct.
Yes, no objection.
All right, 255 is received if it was not before.
And Your Honor, Exhibit 122, which our records identify as the MPD Crisis Intervention Training PowerPoint, we believe was referenced, may not have been formally offered, but we would offer it this time.
Can I have a moment to chat?
Sure. And the number again, Mr. Frank?
Your Honor, upon further review, we would withdraw Exhibit 122.
All right, 122 is withdrawn.
Your Honor, then, just for clarification of the record, if it's necessary, Exhibits 624 and 628 were just only used to refresh recollection, not offered as exhibits.
Understood. Marked but not offered or received.
I believe that clears up the rest of the questions.
Those were just offered to refresh recollection. You said they were never offered formally.
Correct.
Mr. Schaefer, anything else that, any other loose ends?
I think we have it, but can I get the inclusive number of the demonstrative from Dr. Chauvin? Did you say it was 922 through 951?
922 through 951.
Okay. Are we ready to talk about the milestone camera and the player?
Yeah, that was the next thing on our list.
Mr. Nelson?
So, Your Honor, our request was that the milestone video that was introduced, I believe as exhibit that the state introduced as exhibit number 11, which was the milestone video in its entirety, but it was cropped and excerpted, meaning it was not the entire 3 hours or whatever. It is the defense position that we don't have an objection to that being excerpted as far as the length of the time. However, it's our position that the actual evidence in the case would include the player for the milestone as opposed to a recorded version of it. The reason is, Your Honor, when that exhibit was demonstrated or played, published in court, it appeared to be very choppy. It appeared to be at a reduced period of time. I don't know if that was simply a computer problem or some technology problem. When I look at it on my computer, I see the same choppy thing, choppiness to it. The milestone player, as was testified to by Lieutenant Rubel, specifically allows the camera to zoom in, zoom out, be manipulated. You can see that in the video, the user of the video is actually doing that at times because the cameras can be moved. That's the actual exhibit, and it allows the jury to interpret that video accordingly. The submission that was conditionally accepted is not the actual exhibit. It's not the best evidence.
Mr. Frank?
Thank you, Your Honor. I'm not quite sure what best evidence rule has to do with it, but let me just say it this way.
I think he was using it as a phrase and not the rule.
Yeah, probably, I guess.
Say again?
Not sure anybody really knows what the best evidence rule means anymore, so I'll move on. Your Honor, we offered Exhibit 11 for a specific purpose, and that was for the 911 operator, Jenna Scurry. It was cropped because the Speedway sign occupies a big corner of that video. And so that's why it was offered as Exhibit 11. We offered, and the court received, Exhibit 42 through Lieutenant Rugel. That was the milestone video of about 49 minutes long. That is the full video. It has the Speedway sign. It's from the time that Mr. Floyd is at the store to the fire truck leaves. That's the full video that we intend to offer. It plays we still believe that the slight catching of the video was just simply a computer issue at that time and getting it to load and play. Before we send the exhibits back to the jury, we'll of course make sure that it plays at its normal speed. But that's the actual video, and that's all we intend to offer. It plays, and that's all we intend to offer.
Is 11 a subpart of 42?
Correct. And I apologize, Your Honor, I was referring to the wrong exhibits. But yes, 11 is a condensed, excerpted, and cropped version of 42.
So we're just talking about whether the player should go back for 42.
With the same length of time, and that would be our position, yes.
How did Lieutenant Rugel play it when he was testifying?
Your Honor, we had an offer of proof with Lieutenant Rugel, where when it was originally played, the jury went out, and I showed how it would actually worked with the player.
So, what's the state's position about sending the player back?
Your Honor, I think the jury should receive the video itself and not be given the player so that they can zoom in and zoom out. They should have the evidence that is the video and not the player. That's our position.
Mr. Nelson?
It's not the milestone video without the player, and so again, it's within the province of the jury. They may not use that feature. I mean, it is the evidence.
It is the video. We laid a foundation for it through an expert who works in the field. It's the video itself.
All right. If you've tested it out on the computer that's going back to the jury and it plays smoothly, I'm going to deny the request to send the player with because the tools of the milestone video player were not used as part of testimony, and the evidence itself is the video. And so to allow the zoom and other features were not really offered as part, and so but if it's choppy, the player is going back, pure and simple, because they have to have a way to play what is, as the state says, the evidence, and that is the video. Can't be choppy, can't be a different speed. It's got to be real time, going ahead with the player or not. So let's make sure that happens, and if the state can make sure you represent back to the court that it is in working order. And I'll assume it is, but please verify that you've done the testing. Thank you. Anything else that we have to clean up? Mr. Slisher?
If I may, counsel indicated in the bench conference today that he has a motion that he wants to make. He wants to address that.
Oh, yes. We went immediately from the state resting into the defense case. I had assured Mr. Nelson off the record to maximize the jury's time that he could reserve his motion until we had a break when the jury was not present. Accordingly, any motions he makes as far as a judgment of acquittal are timely, and they're just being memorialized at this time. Mr. Nelson?
If we could take that up tomorrow morning, perhaps come a little bit before the other hearing.
Let's do 8:45. We should be able to do most of this. All right, we'll take that up tomorrow. Any other motions? I did want to memorialize, I think you said it was 1053 was the exhibit, the excited delirium slide deck. Is that correct?
Correct. I believe it's, let me just double check here.
In any case, we had a Chambers conference at the state's request to talk about redactions, and I did order redacted one picture out of that because it was not relevant, and given the very limited purpose for which it was offered, deleted the picture that showed someone being restrained in the prone position with a knee on the neck. It was not part of the excited delirium presentation. It was just coincidental with some of the facts we might have here. So that photo was redacted, and also there was a list of references at the last slide. That was deleted because we don't want to have the jury look at that and then decide to do some internet research. Not that they would have the tools back there, but in deliberation, but nevertheless. So those are the redactions that I was aware of. Is that correct?
And I completed those redactions over the lunch hour. I've provided a copy to the state.
All right, and that will receive that redacted version as Exhibit 1053. I think that was all the bench sidebars that that were substantive. Everything else seemed to be non-substantive scheduling. Anything else that we have to make a record of before tomorrow?
Your Honor, we have been just taking notes of bench conferences throughout the course of the trial.
Sure.
And in terms of some of the bench conferences, at least from our position, and I'm not expecting the state to respond to these immediately, but in terms, I just want to memorialize some of the conferences that we've had either in chambers or at sidebar. Your Honor, it is based upon our recollection that on March 30th of 2021, in a morning chambers meeting, in terms of the adolescent witnesses who testified that the court directed the state to lead the younger witnesses, gave them permission to lead the witnesses. That was all within the context of the discussion about whether they would be videoed and audioed and things of that nature. With respect to Mr. Williams's testimony, there was a sidebar where the defense objected. I think you sustained the objection as to Mr. Williams being a security expert. Just wanted to note that that was the substance of that sidebar. At sidebar, a second sidebar, there was a defense objection as a repetitious questions about Mr. Williams feeling that Mr. Floyd was in danger. The defense objected to that.
May I make a suggestion, Your Honor? If we could maybe shorten this up, perhaps email us summaries of bench conferences, we could take a look and then have something that we agree to that we're able to present to you tomorrow.
I think that's reasonable. We'll get that sent out tonight.
All right.
Just one last thing, Your Honor. In terms of just, as the court is aware, there's been ongoing disclosures that have been going on throughout the course of this case. And I think we could probably have a chambers conference regarding a couple of things if the court would be so inclined. But based on my records, at the point that this trial started, we had received 29 disclosures totaling 45,118 bait stamps items. As of yesterday's date, we were up to 41 disclosures totaling 50,272 disclosures. There have been some discussions, and I know that there have been more disclosures that have come in since. Some of these disclosures involve potential impeachment materials of expert witnesses and things of that nature, and they are quite voluminous. And so if we could have a discussion about what, if any, of these materials the state would intend to impeach with, that would potentially be helpful. I think we're up to, as of yesterday, we were at 50,272. So it would be very helpful to help have a meaningful opportunity, for me to have a meaningful opportunity to review those between now and tomorrow, when I expect a couple of experts to testify.
Are these related to your experts?
I believe a significant portion of it is.
All right. Since the disclosure is fairly late, I'm not saying untimely. I'm saying, but it is late in the game. I would ask that the state meet with Mr. Nelson and kind of indicate what it is you're planning on impeaching with.
Your Honor, we continue to be of the position that those are matters we have actually no duty to disclose other than the court's order in this case that we do them. Of course, that order was made at a time recently, and we have been disclosing those things that we had, and that as we continue to get, of course, as we prepare for these witnesses. They may never be used, but they're potential for impeachment, and the court ordered us to disclose them, so we're doing that.
Right.
Now to further ask us to tell counsel what we're going to use to impeach, it's a little difficult to do before you hear the testimony.
Well, I could continue the trial, so give them time to prepare.
I don't see a need to do that, Your Honor.
I think that this is my point. I'm not saying the state is acting in bad faith, not at all. These things are moving targets. But when we are actually in trial on the eve of Mr. Nelson calling these witnesses, and I would not restrict you to what you could impeach with. I'm just saying what you know you will use to impeach these witnesses, if you could at least highlight those, reserving the right to put other things in. Because I'm sure there's stuff that right now you know what you're going to use to impeach. Other things maybe, maybe not. The maybe, maybe nots, I'm fine with you just waiting. But if you know there are things you're going to impeach with, I think it is appropriate, given the fact that these are being disclosed late in the game, again, not making any accusation of impropriety, just they are late in the game. I don't want to have to give Mr. Nelson a continuance and have the jury sit around to give him an appropriate amount of time to prepare. What I'm saying is it gets us to putting these witnesses in front of the jury quicker if we just work together on highlighting things. So I am ordering the state to at least what they know for sure they're going to impeach with.
Understood, Your Honor. We'll do what we can.
All right. I appreciate that. Okay. Anything else for the record? I do need to talk to you in chambers about an issue that relates to security.
When?
Security, everybody. I need counsel. Just counsel. All right. Thank you. We are adjourned for the day then. Let's get back at 8:45 tomorrow for the other issues.